Okay, we're gonna go ahead and get started here. First of all, I miss all of your faces. I can't wait for us to get back to the Cepm table and have real roundtable conversations like we used to. Today's meeting is gonna be pretty simple. We just have a couple things on the agenda. So we're gonna talk to Showdigs, who's our vendor sponsor for today. And then we're gonna speak with Pete Muscio from Shutter Sulzer about the source of income bill. And then I'd like to chat about the CLLC here to everyone that hasn't heard of it. So let's go ahead and get rolling. Is Showdigs here? I don't know if I'm.
That's me, Alex. Hi.
Oh, there you are. Hey, Daniel, how's it going, man?
Good. How are you?
Good. So if you want to just, I've heard about your program. Sounds pretty awesome to me. I think a lot of us are done with, inspections and possibly showings as well. So we've been looking at maybe using you guys, and I think you're pretty new to this market, right?
Yes. So we've been operating in Denver metro area for about a year, and some of our Denver clients kind of have some doors in Colorado Springs, and they were kind of wanting us to look into expanding to Colorado Springs, and also, conversations with you, Alex, and a few other local property managers. And yeah, we would love to expand our service to Colorado Springs. And hopefully today I can show you and tell you a little bit about how we can help you with your field work.
Yeah, so can you talk about, to the group here, kind of what those inspections look like and what kind of inspections that you offer?
Yeah, absolutely. I did prepare a presentation. If I may share my screen, I can show you guys.
Yeah, I'll make you the host, and then if you just switch it back to me when you're done, that'd be awesome.
Perfect. Or maybe I can just share without being the host. Oh, no.
It doesn't let you unless you're the host, unfortunately.
Gotcha. So I'm the host now, yep. And I'll consider giving it back to you. I'm kidding. I'm joking. Can you see my screen okay?
Yeah.
Awesome. So we're basically trying to solve the problem that prevents property managers from scaling up or scaling up and down as needed. Because we all know that, leasing is a seasonal operation, and we want all our leases to expire at a certain time, between March and September typically. And then that's when we see that uptick in showings, and winter, we see a drop. So it's hard to scale up and down and have the right amount of staff to manage that. Same goes for move in and move out condition reports or periodic reports. So we're trying to enable property managers to tap into a network of active licensees. And you can kind of think about it like DoorDash or Uber for property managers, basically giving you a platform that enables you to tap into a network of local real estate agents that would take on those field work activities on your behalf, and you will only be charged a flat rate per showing, per condition report, move-in, periodic, open house, even drop a lockbox from your office to a property. Anything that you need done out in the field, you can use to accomplish that. And I just wanted to show you what it looks like from my end. So you can see my screen right now. I'm looking at a map of the West Coast, and we started in Seattle. So I'm going to zoom in to Seattle metro area, and then you can kind of get an understanding of what it looks like from my end. So as I zoom in, you'll see a bunch of pins that represent properties on our platform. You'll see a bunch of faces. Each face is an actual property manager, actual real estate agent that is using our app, and we can ping these agents in real time to get them to conduct tasks on your behalf. They're all vetted, they're all background checked. They've gone through our training, and they also have a fair housing certification that we make sure they complete. And we have an E&O insurance in case they, make a mistake while operating on your behalf. That's how it works. Kind of the same like Uber. So as far as your prospective renters, they can ask for a showing same day, up to 75 minutes in advance. We'll match an agent to conduct that showing, or you can make a decision to conduct that showing by yourself with one of your own in-house staff. In that case, that's free. You just get to use our scheduling app for free. If you can fulfill all those 2 requests to come in, by all means, you can take it over. If I go back to the presentation, so basically, network of agents, they can do whatever you want. You're able to empower your prospective renters to just book a showing on the spot. They find your listing ad on Zillow. We reply automatically with text to their mobile. They'll see unlimited availability. They'll be able to book a showing, get a confirmation on the spot, and then either you take it over with your staff, if you can make it, or a Showdigs agent will take it over, send you a tour report when the tour is completed. It can be done the cycle can be done in 1 day. We also offer additional services like move in or move out reports. I can share what it looks like with everyone. Annual condition reports, if you want to have a report before a lease renewal, lockbox placement, open houses. You can also share the prices if you want. Everything is a flat rate, so it's very predictable. And that's basically it. Love to answer some questions if you guys have specific questions. And Alex, if you want me to kind of show what a report looks like, of condition report, love to do that as well.
Yeah, so let me speak about that. I don't know how you guys are handling, let's say, renewals, or if you're doing a visit in the middle of the year. Many of us probably already have staff that do that. But something that we are looking at doing, instead of, as we grow, hiring somebody else to help that person, we would simply allow them the opportunity to use Showdigs for X number of reports to kind of ease their load. And so there's many ways to kind of integrate that. I'm not a huge fan of getting rid of physical staff to replace them with this kind of a system. And I don't think most of us would do that either. But I think that over time, if you set a plan in place, you can kind of integrate this kind of a process to help your person. And even though we do a really good job, your reports look pretty darn good. I mean, I'd say they're as good as ours, if not better.
Yeah, let me stress again, Alex, our platform is designed so it can complement your existing staff. And you can use it as much or as little as you need, as you scale up and down. If you have one leasing agent, for instance, they might not be enough during the summer, but they're enough during the winter. So you can use us only during the summer. You can scale up and down. That's the cost of Showdigs is variable, it's not fixed from that standpoint. This is an example of a periodic condition report. We use a platform, an app called Happy Inspector. So that's just, we didn't design the app, we're just using it. A lot of property managers use it. We feel like it has very nice reports that they are able to generate. Our agent will we will handle all the scheduling for you with the tenant. Obviously, the agent will wear all the PPE equipment required, maintain social distancing, and we'll just go by room, grab a few pictures, also under sync, focus on the bathroom, things that can, require repairs or deferred maintenance, search for any lease violations, and whatever you want to be made aware of, you can then, you'll get it in your inbox. You can review it before you want to share it with your owner. And this is something that we complete once a year for most of our clients, maybe twice a year, depending on the property management agreement that they have with their owner. We also have move in or move out reports that happen when the property is vacant. This is, a condition report is when the property is occupied. Those are a lot more thorough, and you'll have, you know, twice as many pictures. It takes longer to complete. You know, our agents are trained to really capture the condition of the property after a tenant has moved out or before a new tenant moves in.
Daniel,
You guys know what you're looking for.
Sorry, did you have a sample of the inspection that you guys do or can do?
So can you guys see this screen that I'm sharing right now?
All I'm seeing is the slideshow.
Oh, gotcha. Okay. My bad.
No problem.
Let me try again. Now you should be able to see the condition report, because this is what I was babbling about. This is what a periodic condition report looks like. It has all the notes per section of the property. And again, this is with an occupied tenant. So we're looking for all the places where there could be repairs needed or deferred maintenance. We're looking for lease violations. You'll get a bunch of pictures and notes per area of the house. And this one is $75, flat rate, no matter how big or small the apartment is or house. And you get this in your inbox. You can review it and then share it with your owner. You know, it's important to mention these are done by active real estate agents, active licensees. We're not hiring inspectors. It's not an inspection, it's a condition report. Just want to make that clear. But yeah, we do all the scheduling and with the tenant, make sure it's the time that works for them. Get it completed within 7 days of the order.
Awesome. Thank you so much. Can you pull your slideshow back up with your email address again?
Absolutely. Yeah, I can drop it on the chat also.
Okay, that'd be great. Yeah.
Yeah.
So if anybody wants to get pricing, I know a couple of you have reached out to me just in conversation about kind of being burned out on inspections. I know after doing this for many years, I think doing move outs and move ins is probably my least favorite thing. So if you just want to outsource that and let them handle it, this would be a really good option for you. So reach out to Daniel and crew for a demo if you'd like. I think I've heard only good things. So
Yeah, that'll be awesome.
yeah. All right, Daniel, could you make me the host again, sir?
I think I have.
What proper beard?
Okay.
Yeah, I think I am now.
Yeah.
Thank you. Appreciate it.
Thank you, guys. Thank you so much for your time.
Yeah, and you're welcome to hang out as long as you want.
Love to. Love to.
Okay, let's go ahead and jump into our main topic here. You know, I think that we all are kind of maybe have some degree of stress about the upcoming changes to source of income, sort of how best to handle that. Something that's really important before we kind of dive into this and before I introduce Pete is we can still screen people's credit scores. You know, we can still ask for credit scores. And I'm sure Pete will go into more detail on that. I can tell you as a company that we stopped using housing several years ago, but for many years we used them even though we had our minimum flat criteria for credit score. And after we implemented our minimum credit score, we didn't get but like one housing person in a 2-year period. So if you have any stress, I can pretty much tell you that I personally think this is going to be a pretty minimal impact as long as we are handling it properly and responding to those do you accept housing questions when they call our front desk, which I think is sort of what we're trying to set up here in the conversation with Pete. So Without further ado, Pete Muccio. Am I pronouncing your last name right?
Pretty close. Yeah, it's Muccio.
Muccio. Okay. All right. Well, it's really good to see your face, Pete. I've emailed you for years. So nice to meet you, and thank you for coming and taking your time to speak with us.
Yeah.
Do you want to kind of take the floor, or do you want us just to barrage you with questions? 'Cause I'm pretty sure we got a lot for you.
I will, you know what, I'll give you kind of like a snapshot. I think you kind of you queued up the issue there a little bit. Maybe that'll help kind of answer some of the basic questions that might be out there. And then yeah, open up to questions and you know, see how I can help answer things. So for those of you that don't know me, I am an attorney. I do have a beard, so I don't look like I'm, you know, too young. I've been saying that for years. I've been practicing with the firm here since 2003. So my beard has a little bit more gray than it used to, but it's a good line, so I'll keep using it. So just to dive right in with what we're talking about is the beginning at the first of the year, there's going to be a new requirement that source of income is now a sort of protected class. There's a prohibition that would prohibit landlords from discriminating based on the source of income. So this is an amendment to the Colorado State Fair Housing Act, and source of income is now a protected class. So what is source of income? Source of income means any lawful and verifiable source of money that's paid directly or indirectly on behalf of a person. So that can include income derived from some profession, whether it's a lawful profession or occupation or some rental payments. So the big one there, obviously, is talking about Section 8 payments. Prior to this law, there were, for those of you that might have dealt with any properties in Denver or in Boulder, there were source of income protections that were passed there as well. But essentially right now, beginning in January, landlords are not going to be able to refuse to rent or to otherwise make housing because of a person's source of income. They can't deny a source of income. A landlord cannot simply outright refuse to accept Section 8 housing choice vouchers. Is kind of a big, you can't have an advertisement saying, you know, no Section 8, right? So there's a couple things to consider with all of this. You want to be on the lookout for different types of source of income. And, you know, to be aware that, you know, just before you say no, that you're going to have to consider alternative sources. You can't refuse to rent. You can't refuse to show a property. And discrimination is quite broad in the sense that it's used in this new law. So it's related to conditions or privileges related to rentals. Okay, so it means you can't treat a source of income tenant or applicant in a different way. So that's important, because you can't say, okay, well, you're a voucher person, we're going to put you into the this voucher protocol, right? As far as the screening process, you've got to screen everybody the same way. You can't advertise no vouchers, and you know, you can't say, look, we're not accepting Section 8. That's not permitted. Let's see. So again, if anybody had dealt with this in Boulder or Denver, not sure how many people here are dealing with that, but that's something that's not really anything new because of the rules that have been in place there for the past year or so. Landlord, the definition in this is very broad, so it includes somebody that owns or manages properties. So everybody that's responsible for compliance could be liable for violations of this. Let's see what else. There are exceptions, but the exceptions, again, going back to that definition of a landlord, probably, I believe most of the people on this call are managing or involved with more than 5 properties, right? Is that fair to say?
Yeah.
Okay. So there's an exception if you own 5 or few, or you manage 5 or fewer single family properties where you'd be exempt from vouchers. If you've got more than 5, you're not exempt. Okay. So like Alex said, the new source of income law does not prevent a landlord from running a credit check, provided that a credit check is run for everybody, right? So you have to be consistent with that. You can't subject a Section 8 applicant to a higher level of screening or tighter screening. So then say your standard is 3 times the amount of income. We recommend that when you're doing that screening, that 3 times is the 3 times the tenant's portion of the rent. Okay, so that's one of the more common issues that pops up is, well, what do you mean as far as, when you're talking about somebody has a subsidy of some sort, right? How do you count that subsidy? So the safest and probably the most common approach to deal with that, let's just say the rent is $1,000 and say the voucher amount is $800 and the tenant is responsible for the remaining $200 based on the nature of the voucher. Then the tenant would need to income qualify based on the 3 times of the $200 portion of it, right? So the thing is, when you look at the voucher, and there are multiple different programs that are out there, it's not the same thing as cash. So it's not really the same thing as income. And the reason for that is because the voucher goes to a specific purpose, right? The voucher might go to a specific purpose of housing. You can't go into the grocery store and say, hey, look, I've got a voucher. I'm going to spend this on groceries, right? It's limited to the housing portion of it. So it's different than just typical income because it has that limitation and it can't be spent on something else. So really, when you're looking at the tenant's portion of what they might be paying, you're looking at that limitation as far as that income qualification. So it wouldn't really be fair necessarily to say, okay, well, we're going to income qualify somebody when their voucher is already taking up a good portion of the rent. So that is kind of a broad overview of what you're talking about as far as that source of income protection. I'm sure that probably raises a few questions.
Yeah, real quick, before we dive into that, Daniel, could you hover your mouse over my name and the 3 little dots in the top corner? Can you click the make host? Because I'm still not the host. I don't see that on there.
Where is that again?
If you hold your mouse over, or the little hand over my video, and then click those 3 little dots, and then click make host.
Just a second.
Just so I can mute.
Yep.
And stuff. Okay, thanks.
Done. Sorry about that.
No problem. Okay, so Pete, I think the conversation with you first started when I sent you an email that basically said, okay, I know that we can require credit, but one of the reasons that we stopped doing housing, and kind of the straw that broke the camel's back, was once we approved a housing tenant, it could take 2 or 3 weeks before they actually performed the initial inspection. And they can't sign the lease until that inspection is done. And so we're basically holding a property off the market, crossing our fingers that it passes so that we can cross our fingers that they sign. So that was my biggest issue. I think the problem is that if we say, yes, we work with housing, but you have to sign a lease within X number of days like you would with anybody else, there could be like a disparate impact connection, because you're basically creating a policy that eliminates all Section 8 people because the program doesn't cooperate with that kind of requirement. Can you speak to that really quickly?
Yeah, so that is that's a good point. Again, this restriction that you can't have sort of this separate process or these additional restrictions for somebody that is that has a voucher or based on their source of income, right, would also it could apply to disparate impact. What is disparate impact? Disparate impact is maybe something where you're not saying on its face it's discriminatory, right? You're not saying, look, I won't allow somebody. An example of something that's on its face discriminatory would be, I don't allow tenants that are in wheelchairs, right? Okay, well, that's clearly discriminatory on its face. You can read that. Something that has a disparate impact is something that's not on its face discriminatory, but the impact of the policy is that it has a discriminatory impact. When you have a source of income protection, if you were to have some sort of restriction as far as the signing of the lease or not allowing the inspection to take place, then that could have an impact on everybody with a voucher, because nobody with a voucher would be able to rent your property because they couldn't sign off on the lease before the inspection had taken place. So if that were the case, then you could be opening up the company, yourself, your owner, to exposure for a discriminatory practice because it's having a disparate impact on people that have vouchers as their source of income.
Yeah, that's super helpful. So we had the question down here, what about houses that don't meet the housing requirements? So for example, there's a bedroom in the basement that doesn't have the appropriate height for an escape size window. It's not going to pass. So I would imagine we're fine with saying, you know, we do accept Section 8 as a company, but for this address, it's not going to work because this house does not meet the physical requirements of housing. What does that look like?
Yeah, that's an interesting question. I mean, you've got something that's not going to qualify. You know that it's not going to qualify, right? Based on maybe it's previously been denied, whether it's the ceiling issue or not. You know, I think there's always a little bit of risk still if you're saying, you know, just right on the front end that, look, you can't use a voucher on this particular house. You know, if it had previously been rejected in an inspection because of the layout, because of, you know, if you're counting, you know, there was a height issue or something like that, then I think that's one thing. I think if it's a preemptive, you're saying, hey, look, this is not going to qualify. I think that's a much riskier position to take. And you'd almost rather go through the process of saying, hey, look, let's get the no from the inspection before we give a preliminary, no, this isn't going to work.
And I guess to play it safe, instead of saying this property, you couldn't take this one because it doesn't qualify, you could say, you know, there are some challenges at this property because the escape size windows in the basement bedrooms may cause you to fail your inspection, and then kind of let them tell you, okay, well, that's not going to work then.
Well, I mean, yeah, that is an issue. I guess the other issue though too is if it's not going to qualify based on if there's going to be an issue with the basement anyway, if there's a fire code issue, then should those be treated as a bedroom? That's sort of the bigger issue, right, with that property and renting that out. There might be other concerns there. If that's not qualifying, then maybe that shouldn't be treated as a bedroom because you could be running some additional risks as well. I know that's kind of a side issue from that scenario, but I just wanted to point that out, that if you have that particular situation pop up, you know, there are definite risks that could flow to broker owner of sort of mischaracterizing a bedroom in a basement situation that would be violating the fire code. And when you talk about violating fire codes, you know, it's not just the worst case scenario risk. When municipalities take action against landlords for code violation issues, those are actually criminal charges as well. And so they can have that municipal court, and those types of violations can have criminal penalties. So it's really a road that you don't want to go down for multiple reasons.
Yeah, it's another question that came up for us in our office because we have we require credit scores and we require a social security number, but we have an exception in our policy if it's a Canadian military person, where we will take an ITIN number. But so that's something that we would have to think about, right? Because if we're requiring a social security number except for this one group, do we have to have an exception for all groups or no groups?
Yeah, so that kind of gets to another proposal that was passed, is a restriction on the ability to discriminate based on citizenship. So certainly it is advisable to take a hard look at requirements related to social security numbers. In fact, I know some companies are taking a look at just doing background checks based on birth date now and moving completely away from social security numbers. The reason why is because if somebody doesn't have a social security number and your policy says, hey, look, we're going to say if you don't have a social security number, can't do a background check, or we're not going to qualify you. What is the potential impact of that? Again, it kind of goes back to this disparate impact issue, right? That same sort of thing, like who doesn't have a social security number? Well, it could be somebody who maybe is here illegally potentially, or somebody could be here legally and doesn't have a social security number. It could create a problem. So that's another that's another thing to take a look at, and goes into effect at the beginning of the year as well. So,
Well, for the immigration status bill,
Yeah.
I'm 99% sure that it references the ability for a landlord to still require a social security number, assuming again, you do it across the board, which is kind of leads to the original question, which is if you're going to not require it on a Canadian military person, you need to rethink what kind of liabilities you want to take on if you're going to be having a variable policy for that.
correct. And so you can still have the social requirement, but the thing is, you have to also have an ability to accept a client even if they don't have, or accept a tenant even if they don't have a social, right? So you need to be able to sort of look beyond that box, because if you're just limiting it to the social, you are potentially setting yourself up for a challenge there. So.
That's definitely going to make me go read the bill again, because I was pretty sure that it said you specifically can do that. But well, as it pertains to additional housing related questions and the housing related challenge here, what other questions do we have? Feel free to speak up if anybody just wants to unmute themselves.
I have a question about basing it off of the tenants portion when we're approving them for the housing. You're saying we only need to approve them if, say, their portion's $200, we're to approve them on 3 times the $200. That often changes throughout the year depending on who's coming in and out of the property, whether their job changes, employment. I mean, how can we justify using just that amount? I've got a tenant once that went from owing only $150, and next thing I know, they owe $740 a month.
Yeah, that's a good example and a good challenge that I think the industry is going to be facing when dealing with this, right? And there's just there's no good answer as far as what that protection is going to be for the landlord in that situation, right? Because if you have somebody that changes that drastically, it might be in a situation where you would think, are they going to be able to afford to remain there? However, I would say if it's changing that drastically, typically there's going to be a change in the income that is part of the justification for that change. That hopefully they would be able to maintain the current rent. The thing is that you've got to look at you've got to sort of accept the situation of where the tenant is at the time that they're coming to you, right? So when they're coming to you, you've got to look at that qualification. It's not necessarily okay, what's going to happen 6 months down the road.
Hi, Sherry Dia Brown. The number one reason that we stopped accepting Section 8 was because the tenants were not being respectful of the property and not returning it in as good condition. And when we asked whoever was the reason they got the voucher, the source of their voucher for accountability, this person was not a good, caused damage to the property. There was no accountability from the source. They were like, oh, well, so source of income isn't helping us deal with the fact that sometimes people who have privileges or financial support also don't come from responsible.
So I think that ties into something that I'm sure Alex is going to touch on.
It could be that there's no plan available.
I think Alex is going to touch on in a second too, but it's important that landlords' voices get heard at the legislative level as these things get proposed and passed. And I know our office has been heavily involved in various ways as far as trying to garner support for the industry. I know Alex has testified down at the legislature on multiple occasions dealing with various issues. And I think it's important that landlords' voices and that concern in particular gets shared. I know that that is a common concern, a common issue, and a big reason why a lot of landlords have held off on accepting Section 8. There's sort of the sort of two schools of thought mainly that some people look at it and say, look, I'll accept the risk of what's going to happen because I just want a steady source of income coming in, and that's my main concern. And then the other concern is, look, I want to protect the property as much as possible and be able to hold whoever's there accountable for those potential damages that might occur beyond normal wear and tear. And it's a tough balance, and there aren't a whole lot of additional protections that are available to landlords in the situation where if you have a resident that is on some sort of subsidy and then does significant damage to the property, a lot of times the collectability of that resident after they leave is going to be quite limited. And there's just not a whole lot of recourse that can be done in that situation, unfortunately.
Sure, I'll speak to that too for just a minute. The company that I used to work for, we had a lot of housing tenants. So I've done a lot of housing. We had problems with that too, where they would vacate and cause damage, and frankly don't have the money to do any repairs, even if they wanted to. We have had some success with basically speaking with the housing authority and saying, they owe $2,000 or whatever. And then them telling the prior tenant, you have an obligation to set up a payment arrangement, or we will put you up for a removal of the program. The problem is that there is no board, there is no review, there is no hand-holding in that process. So if the tenant is willing to make any kind of monthly payment, they're probably not going to be removed from the program. That could be $5 a month, or $5 a month, or $10 a month. And I actually had a tenant who paid $10 a month for like 5 years on one of those. So with that being said, from what I've seen, there is some ability to leverage and require them to set up a payment arrangement on a balance due if you escalate that with the housing authority. But how much they actually have to commit to is so subjective. I'm not aware of any fixed policy that they have to commit to any kind of reasonable dollar amount or anything like that. So
yeah, I still have one tenant left, but actually they've been there for 10 years and they're actually a good caretaker, but has not been the norm. So yeah, this is going to be interesting.
Well, that's good to hear. I get kind of a jaded perspective on things sometimes because nobody ever calls me up and says, hey, Pete, I just want to let you know I've got a situation with a tenant that's going great, right? They're paying rent on time. There's no damage. It's really smooth. And just wanted to let you know that. I never hear those stories. So, it's glad to hear that there's some positives that are out there.
Yeah, I have one.
So I have 4 Section 8 properties right now. And I just placed one of them, qualified on everything, and it is going great. The other 3 were in place when I picked them up. And any inspection I do, anytime I've been down there, they've been lovely to work with. So I do have good stories coming from it, but placing them and getting everything started with HUD is fairly difficult. All in all, this won't change Falcon's business too much, but it's going to be difficult.
I'm kind of the opinion that we should probably all have some kind of canned response when we get that question. Do you accept Section 8? And I will probably be asking Pete for help with that language. But, they call your office and they say, do you accept Section 8? You almost want to say, we absolutely do. Can I get your phone number so I can text or your email so I can email you details about what that looks like? And then say everything perfectly that you're not going to say perfectly when you're on the phone with them. I feel like that probably would be a best practice. How do you feel about that, Pete? Yeah,
I mean, I think the important thing is to sort of have an open door policy, right? And that you're considering that tenant and you're considering Section 8, and you're going through that process. Whether or not they're still going to qualify based on background or whatever, I guess remains to be seen. But you've got to sort of, for those who have come from the world of we don't accept Section 8, we haven't been accepting Section 8, this will be a shift. And you'll have to go through that process. I guess if that's the one thing to sort of take away from this discussion is that, knowing beginning in January, there can be no more blanket, we're not accepting any sort of subsidy situations.
I might not be getting all the questions on the side. I'm sorry. Who did I just cut off?
No, I just had a question in regards to, it's probably not smart to have a policy where a tenant is required to sign a lease within however many days of their approved application, because that could create, a discrimination against Section 8. But would it be possible to, or smart, I guess, to have a policy that you could implement across the board that, says basically if you, will hold a property for up to 2 weeks upon an approved application, if the lease is signed after that 2-week period, prorated rent will be due from any days beyond that 2 weeks. I don't know if that's making sense. But, so that way we can capture rent without indirectly discriminating against Section 8.
John, it's an interesting concept. I'd say my concern, just right off the bat is you want to go with the approach of we're treating this applicant the same as you would another applicant. And it's different because not every applicant has an inspection. So, you look at it and it's like, well, wait a minute, how can we treat them the same because they're in a different position and they're going to have to go through this process. So when they go through that process, you've really got to make sure that whatever steps they're going through, you're not putting up an additional barrier, right? And because that barrier is going to be looked at potentially in a critical mindset. So I think that's just kind of a framework to consider with whatever approach you end up taking on that, is that you don't really want it to be viewed as, hey, look, this is a barrier to being able to rent this property, because, and what does that look like, right? What does it look like when somebody is accused of some sort of a discrimination? Well, typically, if somebody's accused of a discriminatory practice, a resident or an applicant could file a complaint with the state. When they do that, then the state can open up an investigation and they can look at and basically audit your application practices. They can audit that specific situation, the communications. Those are things that sometimes landlords handle on their own. Sometimes they hire attorneys to do so. There's costs to dealing with that. You could spend thousands of dollars just defending an accusation. So it's a tricky area, and there's sort of costs all around, right? There's costs to holding off a property. There's costs to a perception, or if somebody thinks that you're engaging in a discriminatory practice when maybe you're not, in defending that. It's just it's a difficult area to navigate for sure.
Yeah, I think that whenever we have a new bill, there's sort of this element of this reasonable factor, this reasonableness. And whenever you end up in a gray area, and there's always tons of gray areas in a lot of these bills, unfortunately, you call Pete for, is this reasonable or not? And what kind of risk am I willing to take? Unfortunately, our world is not black and white. We don't know exactly what to do always. It's kind of leading back to that conversation, Pete, about even the immigration bill. Sure, the immigration bill technically says you can still require credit scores, but the more strict law wins, right? So if there's federal law for disparate impact, is that state law language a good enough defense? I think that you decide that as a company, and you get your legal advice, and then you take that and decide kind of which side that you want to fall and how much risk you want to take on. I personally am not a fan of policies that are 100% risk free, because I feel like they're pretty detrimental to not only your company but to your owners in some cases. So I think you have to find that middle ground.
Yeah, there's always a balance. Absolutely. I mean, you can't, there's a risk of doing nothing, right? When there's risk everywhere, and we are in a very litigious society, litigious environment. You can't watch any sort of news without being bombarded by at least a half a dozen ads for attorneys for various matters, right? So it's, you've got to decide what's going to work, what's the comfort level of risk that you're willing to take. And a lot of times, and especially in an environment like this, I've got to talk about the conservative approach. There can be situations where, what works for one person may not work for somebody else. And that can be a more detailed conversation for sure. But, in this type of forum, we're really typically talking about, hey, here's what the law is, and here's kind of the most conservative approach to looking at it.
We do have a question over here about application fees and deposits from Elizabeth. I believe that we're still charging the normal application fees. We're still, requiring the same deposit. We of course wouldn't want to have some kind of a variable deposit for Section 8 people. That would be a problem.
Right.
And Section 8 people pay their own deposits, right? It's been years since I had one.
So yeah, you can still require deposits. You can still require hold fees. The question, I ran into this question the other day is, is there a restriction on affordable housing situations that would prohibit the ability to accept an application fee? And there isn't. But just keep in mind that with application fees cannot be a profit center these days, right? So the application fees really need to be tied directly to the costs that are involved underlying the application process.
Getting back to that conversation about sort of a blanket response for best practice, once Dorman has created that, I will share it on Cepm, and maybe you guys can do the same when you come up with some kind of language for us to kind of roundtable how best to reply to those questions. Trying to see if there's
Hey, Alex.
Yeah.
Our website has some verbiage on it for that. Falcon.
Oh, okay. Awesome. Would you mind, so you've already put something together around that, Maggie?
Yeah, we have.
Okay. Would you be awesome and post it?
You got it.
Cool, thank you.
I'll post it on Cepm.
Okay. What about 48 hours? So Kevin is asking, what about 48 hours from approval? So actually, that's funny because our policy is from approval, you have 48 hours to pay your deposit and sign your lease. So you're saying, so Kevin is asking, what about 48 hours from approval to sign unless otherwise required by law? Because I think the problem is that if you are now you're making the exception for housing only, but for nobody else. Like,
right.
Does that create problems as well? Or can we just say what Kevin just said?
Well, I think the, one thing that pops up a lot of times in the fair housing context is that you want to look at fair housing and say, okay, it's everything fair. You treat everyone the same. And it's actually really not that way, right? Fair housing is, yeah, you do try to have a level of fairness, but there can be certain exceptions or exceptions to different situations, right? If you talk about a reasonable accommodation, for example. What's a reasonable accommodation? It is a request for an exception to a rule based on a disability that would allow somebody to be able to enjoy or use the property in a manner because of their disability, right? It's all related to an exception. So while on one hand you look at it and you say, okay, well, we've got a policy, here's how we do this policy. Well, it's good to have that policy, but as soon as you look at how that applies when somebody is in this exception status, then how that's impacting them, you may have to treat them differently in order to allow them the opportunity to utilize the housing.
That makes a lot of sense. Yeah, so that pretty much answers it. So let's take a comparison. Let's say that you have somebody who, maybe you have a policy in your office where you require the lease to be electronically signed. If you're not willing to electronically sign this, then you're out. You may have somebody who has a disability or some other kind of issue that would prohibit them or inhibit them from having access to the ability to electronically sign. So now you have to print the thing out and have them come to your office. That doesn't necessarily mean that you have to eliminate that policy that everyone else electronically signs. You know, like you said, you don't have to treat everybody the same in that regard. You just have to be willing to make that exception when it's appropriate, so that you're not sort of disallowing those people that fall in that category from renting from you.
Right, exactly. And when you talk about exceptions, you know, the exceptions are sort of justified exceptions, right? There's a reason why there's an exception. There's a nexus, a connection to a disability. You're not just saying, all right, well, you know what, I'm sorry, people that have beards are inherently not trustworthy, so I'm not renting to anybody that has any facial hair, right? You know, so I mean, it's not something that's based on a discriminatory reason or a reason that doesn't make any sense. You're right. You're treating somebody differently in order to help that person.
So
I had a question about what you consider source of income if parents or a friend or anyone says, yes, I will pay this. Is that source of income? And how do you verify that? And does that mean that you must now move them into a guarantor, because we generally do not accept co-signers or guarantors?
That is an excellent question, and bringing us back to that source of income situation. I think you really would have to consider that sort of income situation, and I think you'd also want to consider having that person sign off as a guarantor. You know, if somebody's saying, "Hey, look, I'm committing to, you know, paying 50% of this rent," and you know, then I think if you've typically had a policy where you wouldn't have a guarantor, I think with the new source of income, you're going to want to look at making an adjustment to that policy and allowing that, and potentially doing work with your attorney as far as what your guarantee is going to be. But that's a good way to kind of get that locked down, to have that commitment of that payment.
yeah, I think that even independent of this particular bill, in terms of just kind of best practice, I think it's pretty generally advised that if somebody's committing financially to assist with payment, that you legally commit them to do that by signing the lease or signing some kind of guarantor agreement. We don't typically love co-signers either, but we'll make exception on income specifically. So.
Yeah, but I mean, you could have income from, you know, a variety of sources. Somebody could be receiving income from a trust. You know, they could be it could be a lot of different things. You know, you could have somebody that has a voucher that pays 100% of their rent and their income is zero. You know, so
Can I just go back to that previous question, because we have that same policy. Ours is a little more generous, 72 hours. It takes so long for housing authority to approve that our property, we could have leased it in that time period, and we don't even know if it's going to be approved. If it gets not approved, then we have turned down other applicants who would have been approved. So that really puts us in a difficult position.
It does. I mean, and you know, when you're turning down somebody too, you know, maybe it's looking at that policy of, if you're turning someone down when you already have somebody in place, you can say, look, we've got a pending application. We don't know, you know, how long this is going to take. Of course, you know, how many times do you have somebody that's coming in and saying, hey, look, I'm looking for a place that's a month down the road type of thing. Or, you know, a lot of times it's probably a little bit more immediate. And people's circumstances change. But yeah, that is, you know, one of the things, if you look at what's happened in the past year, I think both from when this legislature, when the legislature was in session and when this was passed, and then you look at some of the emergency things that have been rolled out as we've been dealing with the current COVID situation and the government's reaction to the COVID situation, you've seen a general shift of the burdens associated with dealing with a property that have been placed on the property owners and away from the tenants. And what that has done is it's really been an erosion of the rights of a property owner. I mean, you've seen situations where all these rights that you have as a property owner, your remedies for dealing with a default situation have been put on hold. And they've been put on hold for the reasons that the government has said that, hey, look, there's a health reason, we need to stop this. We need to, you know, slow these things down. But we're not taking away your remedy. We're just giving it to you at a later time. Well, I mean, it's tough. It's a tough situation for the ownership, because now you're dealing with these additional burdens and carrying costs that you weren't anticipating, right? And that trend may continue. I mean, when you look at when you look at the crystal ball, right, and you say, okay, well, what's going to happen as far as upcoming legislation? I think we can anticipate that there might be some proposals that are out there that are going to really reshape the industry as far as what rights both landlords and tenants have and what remedies they have. So again, I'm kind of giving you an indirect plug, Alex, for the influence of making sure that landlords' voices are heard. And it's not just a right and left issue. I think it's really comes down to a practical issue and a concern for the entrepreneurial aspect of both on the management side and then also on the ownership side, and the positive aspects promoted from owning a property and renting it out in an attempt to sort of build wealth and provide housing to other people.
Yeah, I think Michelle's question about the problem of waiting for that inspection is the number one issue with this bill. With that being said, I think that if you are set with a minimum credit score and you're comfortable with that risk, that you're probably going to eliminate the majority of that for anybody. I mean, just for what it's worth, we went to a 600 minimum some years ago. And again, during a couple of year period with setting that minimum, we only had like 2 people, and we think we had like 500 houses at the time. So the odds of you getting a Section 8 person with above a 600 credit score, frankly, is pretty small. So I think that the being put into that risk situation where you're pulling it off the market and waiting for that inspection is going to be pretty few and far between. With that being said, like Pete said, that's why we need to try to go on the offensive. Unfortunately, I think in the next 12 months, we're going to be very much on the defensive. But as we work through this and we see it practically play out, we'll look for those pain points, and maybe we need to start speaking with some legislators to create some bills to amend some of the things that we've been subjected to here. So we do have a question about, let's see here, COVID restricted jobs. Can we give those?
Resistant. Totally different.
What did I say?
Restricted? I don't know.
Can we give COVID resistant jobs preference on applications?
Boy, I think you've got to be careful there as far as giving some sort of a preference to any particular industry, because it could come back to a source of the income preference, right? Like, so anytime you're saying now that, hey, look, here's a preferred situation, if you're in front of the screen, you're going to be preferred unless your job's compared to if your job's a face-to-face situation, right? I think that could potentially run afoul of that source of income, because again, you're discriminating then based on that source of income. So it's a good question, but I think it's a risky proposition.
Hey, Liz, you had a question about source of income and a napkin. Can you expand on that? It looks like your audio is connecting.
I'm interested here just to find out what the explanation of that is.
I don't think your audio is connecting, Liz. That's okay. I think that your question was kind of leaning back to that previous question, which was if you're getting source of income, or if you're getting somebody committing to pay the rent on somebody else's behalf. I think most of us would require proof of income from the person who is signing that lease as a co-signer or whatever it may be. I don't know.
Yeah. I mean, if you do have this, somebody's providing the additional funds that are going to support this resident, it seems like that would be natural to be able to follow up and inquire about the validity of that. And I think that kind of goes back to that conversation about having the guarantor, that certainly taking a look at allowing the guarantors and what's your process internally for evaluating that. If somebody's saying, hey, I'm guaranteeing this lease, but it's just written on a napkin, then is that really going to be strong enough?
Okay, I don't see any other questions in the chat. Does anybody have further questions? I know, Pete, you had blocked out till 3 o'clock. Are you okay with hanging out for a couple more minutes? Or?
Yeah, I got a few more minutes.
Okay.
Could I follow up one more time on the source of income? We have a policy that any out-of-state guarantor, they must pay double the deposit, because the reality is that you can't really serve someone who's out of state, out of country in particular. It's much, much more difficult. So our policy has always been, if you have out of state or out of country, it's automatically a double deposit. Is that going to run afoul of source of income?
This is a good question. So if you're if they're comparing two different applicants, they're otherwise the same, except one guarantor is not a Colorado resident. They're from, let's see, which state are we going to pick on? We'll pick on North Dakota. Very random, I know, don't you know? But but they're from North Dakota, and they've got, you're saying, hey, look, you're from North Dakota, so we're going to have to jack up the deposit. It's interesting.
We do that because it's almost impossible to serve somebody. And we have, one of our buildings is near University of Denver. Mm-hmm. So we have applicants, guarantors who are from China. There's really, truly no way we will ever be able to grab them. So we have that flat pile, rather than saying, foreign students have to pay this. It's just been a flat across the board. If you don't live in our state, it's double the deposit.
I think there's an interesting justification for that, right? And I think it's related to a good business reason, right? Your business reason is that you've got a higher cost of collection if you're dealing with a default situation. And that seems to be, that makes sense, right? It's logical, it's supported. Is it discriminatory? You're not saying that any tenant has to pay a double deposit if they're coming in from out of state. You're saying if you've got a guarantor that is out of state, they're going to have to pay a double deposit.
That's correct.
I mean, to me, I think there's a good justification on that. So my quick, 1 minute off the top of my head analysis on that is I think you're okay with that process.
Excellent.
I think a lot of this also stems from the disparate. Is it disparate or disparate, Betsy?
Disparate.
Okay.
It's not desperate.
It's not desperate. It's definitely not desperate. But
Disparate.
there was some legislation that I understood to go into effect that kind of has been put on hold, that kind of rewrote the framework. HUD basically rewrote the framework for a disparate impact case that put sort of more onus on the complainants to position and prove that the landlord was breaking those rules. But my understanding is that there has been a challenge to that and it's like on hold or something. Do you know anything about that, Pete?
So off the top of my head, I would say there has been some developments in that area. It's always been challenging for somebody to bring a disparate impact case. And I think some of the proposed modifications might make that easier to do so, but I'm not up to speed with it for right now to be able to give
Okay.
you much more than that.
Yeah, I didn't mean to put you on the spot.
No, it's okay. It's
That I feel like the disparate is just overshadowing everything. So
it is. I mean, and I think it's there, and I think it's something to be aware of, because some of these things too. It's not just it's if somebody's perceived that they're being discriminated against, right? And particularly with that citizenship status issue, it's not that if they have a perception that they're being discriminated against, then that could give them a basis for a claim. So,
Sherry Dia, go ahead.
Yeah, I have a COVID question for basically the group and attorney. What's the current thought process on late fees for tenants who aren't paying their rent on time, mostly related to having challenges of whatever on their source of income? But do you think the governor, I mean, at this point, if I'm correct, the governor has said to the end of the year we can't charge late fees to a tenant. This might continue past the end of the year?
Yeah, so right now from October 15th forward, no late fees. And it is possible that we could see some sort of an extension. My guess is we're going to see some sort of an impact with the special session that's going to take place after Thanksgiving, right? I think we'll see some sort of I don't know if it's going to be a relief package, or I don't know what it's going to be, but my guess is there will be something that will have an impact on the industry coming out of that session. But right now, no late fees from October 15th on. So if you had late fees related to October that were incurred prior to the the 14th and earlier, those can still be assessed, but it's just the late fees moving forward.
Yeah, because it was 2 or 3 months where we could charge late fees, and now we can't again. So it's
correct. Yeah, it's like this on again, off again late fee situation. I feel like I might have to borrow Missy's background because it looks like the Tony Romo Corona hotline background, and if we're going to start talking about COVID situations, but. Yeah.
Thank you for indulging.
It also looks like she's on a beach and it's like 12 degrees outside. So I'm also very jealous.
I have one more question. Sorry to be asking so many, but is it, if you're on a Section 8 with a Section 8 tenant and there's damage to the property mid-lease, would there be a way to require them to fix those damaged property prior to the end of their lease, so that at the end of the lease, we still would have a complete security deposit?
So I think I've got two lines to kind of answer that. One, I think you want to be always very cautious about having a tenant fix anything if you're asking the tenant to fix it. But I will recouch that as if you want the tenant to pay for it.
Yes, tenant to pay for it. We repair the damage, tenant pays for it.
Yeah. So that is certainly something you could require the tenant to pay for those damages. The issue pops up though, what if they don't pay during the time of the lease? What if they say, look, I don't have the money, or they're not paying it? Then what action do you take as the landlord? The old playbook used to be that if there was that sort of damage and your lease language supported that you could pass that charge along, that could potentially be the basis for an eviction. A lot of times now, when you're looking at non-payment demands that are having to be 30 days, that might not be the path of resolution that you're looking to pursue. So it might be something where a strategy of reaching out to the tenant, allowing them to make a payment if they can, or reminding them that, hey, look, you still have this balance. We're still expecting this payment from you. still could make sense that you're not using that as the basis for an eviction, but you're just continuing, you're not waiving your ability to pursue that amount. It also kind of can depend on how much of a repair you're talking about, right? Is it a relatively small repair, or is it a bigger balance? Either way, you want to make sure that there's that continuing communication, that you're still expecting that to be paid. Even if you're accepting rent during this time period, you're still expecting that balance to be paid. That will support your ability to be able to pursue that after the lease, potentially.
The other thing, Michelle, is that you could report that to the housing tech. However, if they don't fix it, that could potentially be a reason for them to lose their assistance. And that may actually screw you over more. So do that with caution. Because if they're removed, now you're in a situation where you have to evict them because they're not getting that source of income money anymore. So
I don't disagree, but like if we have Showdigs come in and do a mid-year inspection on non-Section 8 tenant, we would then go in and make those repairs at that point, assuming it's not carpet they're going to replace at the end of the lease, but something. So I would like to be able to treat the Section 8 folks in the same manner again.
Yeah. There's, just because they're on Section 8 doesn't prevent you from trying to move forward with assessing them for those damages mid-lease.
Okay, Ashley, what's your question? Go ahead.
So I haven't had a chance to really fully read this new bill for the income, source of income, but at this point in time, we've never accepted like unemployment or GI Bill as a source of income because it has an end date and it can be affected in different manners. So is this bill going to affect that at all? Would this bill force us into having to accept those types of income that have end dates?
Hold on, I very rarely get to do this in response to a question. Yes.
Okay.
So yeah, so remember that, so the source of income, it's pretty broad, right? So like you can't just say, oh no, that's not good enough. If they have the income, and it's coming from a source that maybe is going to only last for a while, that's still going to be enough to qualify for them.
Well, but here's the problem. So like the GI Bill, that is based off of their, oh gosh, what is the word? I'm sorry. It's based off of their time in school. So like if there's a period during school where there's a break, they may have a period in time where they're not receiving income at all. Or if they take a semester off and then go back, it's all based on them being in school. So it's not, I mean, it's not any form of reliable. It's almost like someone gifting you money because there's no guarantee how it's going to work, when they will and will not have it. So does this put us in a position where we accept the GI Bill and we just have to let the owner know, hey, you may have a period of, a couple of months, they took a semester off, they have no money.
Can I piggyback on that real quick, Pete, before you answer that? So correct me if I'm wrong, but even though it's called the source of income bill is really more about people receiving government assistance to help pay their rent. Does the bill even go into other things other than again, it's been like 8 months since I read the thing. I thought it just specifically addressed government assistant housing, and even though it's called source of income, it actually isn't for broad brush source of income.
And that's what I was trying to figure out. Is it more so like Section 8 vouchers, or is this going to encompass like unemployment, GI Bill, and other items?
It does encompass other items. So it is not just the Section 8. It applies to, it could be, it's broader than Section 8. So it's not just government, or it could be private assistance. It could be grant or loan programs. So all of these things kind of fall under that umbrella. I think a lot of the times the emphasis is on Section 8 because that's probably the most common thing that you're going to run into. But these kind of more unique situations are covered by that.
So I wonder if you could have a policy where you're not discriminating based on their source of income, but they have to have proof that they have not only that 2.5 or 3 times whatever requirement to move in, but they have to have proof that they can continue to make that during the term of their lease. Wouldn't that
That
But
be?
you don't have that with anyone. Anyone could get fired tomorrow.
Yeah.
Yeah,
Well,
that's a great point. Yeah.
yeah, but if they know they're getting fired in 6 months, couldn't you just say no? I mean,
But you can't guarantee that 6 months or 9 months down the road, they're going to be like, hey, I'm burnt out. I'm taking a semester off. I mean, and I only bring this up, GI Bill, we're a heavily military area. I've actually had quite a few applicants that have shown up and say, hey, I'm getting out of the military, but I'm going to have my GI Bill because I'm going to school. And, you know, I'm a military spouse, so I've been around this for many, many moons. And I just want to know how this is going to play into it, because typically we've said, no, I'm sorry, that's, you know, we can't use that as proof of income.
Yeah, I would change that policy.
he said yes, Ashley.
I know. Look, I'm trying. I don't want that to be the answer.
Take yes as an answer, Ashley.
Oh boy.
All right, well, can we take maybe 1 or 2 more final questions before we let Pete go?
Go 2 more.
Go ahead and speak up if you have a question.
Bueller?
Betsy, you always have something to say. What do you got?
I already know everything, so I don't have any questions about anything.
I forgot that. Okay, got it.
Yeah.
Our bad.
Kevin, did you have something?
Yeah, so we actually are talking to a few law firms right now. We're spending a hell of a lot of money, which will be able to help everyone with what we find. One of the things we're looking at doing in the new year, we're looking at our minimum credit score of 6. Because as long as we have a written policy and processing and all applications the same way, we can actually say, look, if someone is 650 to 700, or, you know, you've got to go to the next level, or, you know, you've got to have this person talk to you. Basically, the higher your credit score is, the faster tracked you are to an approval process. Where if you have a set stepped thing in terms of, you know, this is the next step in your process, but if your score is above 700, you go to step 2. If you're 725 to 775, you go immediately to step 3. So we're putting something like that together, and I'm just curious what Pete's idea or thought is on that, if that seems to be anything that would be negative with the source of income type thing. It's just something we're looking at doing, with the whole goal being, if you got an 800 or higher credit score, your application is going to get processed faster.
It's an interesting concept. You know, one of the things that comes to mind is, and I'm not going to recall the case exactly, but I know of a case out in New York where there were sort of multiple steps that somebody had to go through in order to qualify. And at least in that situation, the way that the steps were put together, it was viewed as, look, this is just a huge barrier to somebody being able to apply and to qualify at a lower income level. And you know, keep in mind, New York is a very different place when it comes to housing, right? So that's just the first thing that pops into my head when I hear that, as far as a process. But there's also another side of that too, and that is that there might be a good justification for dealing with that, right? As far as like, hey, look, we got somebody with an 800. Wow, they're on the fast track because, you know, that's looking pretty good. Just depends on what those additional steps could be. So I'd say, you know, if you're going to go down that road, just make sure you kind of get it vetted and have a good plan of approach to that. To make sure that you're not, again, creating that too big of a barrier, and that there's a good justification for what those additional follow-up steps are going to be.
Yeah, no, I appreciate it. It's all structured in terms of, so because there are, just like you said, there are different barriers you can create, which is illegal, and you can't do that kind of a thing. But if we're basing everything first step the same from credit score, and then things start to deviate from there depending upon what's found or what it is. And Cheddar's office is actually one of the ones we're consulting with, just to see, because if everyone says the same thing, great, hell yeah, let's go forward. But if not, then we've got to ask some more questions.
Well, you know, the thing the thing that's a lot of fun about attorneys is that everybody has their own opinion, and everybody likes to justify it and talk in a long-winded, manner type of thing. So it's certainly good to get a feel for, what's going to be the best fit for your company and for your practice. So makes sense.
Hey, Alex, I've got and Pete, we've talked about putting in a policy where we don't accept anybody with a credit score over 790 because they're assholes. I'm just kidding. I'm totally kidding. I just wanted to know if Alex had talked to you about that.
Well, I can't reveal any conversation specifically that I've had with a client, so you'll have to talk to Alex about that.
Okay, got it.
We don't put those ones in writing.
Yeah, right. That's a secret policy.
All right, we're going to look for one more question for Pete. Anybody? All right.
Well, hey, thank you, everybody. I appreciate the time. Alex, thanks for coordinating and giving me the opportunity to meet everyone. So I'm going to sign off, but good luck with the rest of your meeting. And
Thank you.
Yeah. Thanks for joining us, Pete. Appreciate you.
Thanks, Pete.
Thank you.
Thank you.
Thank you, Pete.
All righty. Well, before we go into the next phase here, I'm sure everybody's aware of the governor's order pertaining to evictions and the fact that now the state declaration is no longer specific to non-payment, and that short of somebody basically committing a substantial breach of lease, they're cooking meth in the house or they murdered somebody, you're probably not gonna be able to evict them for any other reason, even if it's not just non-payment. Does everybody know that? Okay.
Yeah.
Does everybody know that we're screwed? Just checking in. Just want to make sure.
Yeah. We are so screwed.
Thank you for the reminder.
Just hard though.
Yeah. Okay. Well, before we finish up, I want to just answer any questions about the CLLC and give you guys a little bit of a background on what this is. First of all, this is effectively a NARPM state chapter that does legislation. It's basically the new NARPM state chapter. The reason it's not the NARPM state chapter is that during the last year, while the founding board of 3 awesome human beings were trying to put that together, they were facing a ton of barriers and bureaucracy from the national NARPM group. And if we would have gone down that road or continued going down that road, not only would they have more control over any funds that were brought in, but they also would delay our starting date to where we could actually make an impact, which means we wouldn't be positioned with our lobbyists for this coming legislative session. And basically the group was not willing to wait another year or two to be mobilized, because we don't want to get more screwed over in the next 6 to 12 months. So the group branched off. They started a nonprofit that is going towards, and almost every dollar goes towards paying for this lobbyist. I think at this point, every NARPM chapter, and there's 4 of them, have joined as members, but we really need people and companies to join individually, even though some of your NARPM dues in theory are going towards the payment that they made as a chapter. We really, really need you guys as companies, as individuals to join. And that may mean, $60 a year as just a base membership, or it may be something like our silver, gold, or platinum levels that we have. If you want to be, in addition to the board that runs this organization, we have an advisory council, which is effectively a group who meets with our our lobbyist liaison to decide on how they want to present recommendations to the board for the lobbyist to take a position on certain bills. So if you kind of want to have a voice at the table, you'd either have to be a platinum member or you'd have to be recommended by one of the board members. So if you want to be involved in that level, feel free to reach out. And I'm happy to.
with the board member stuff, are we talking about our PAC or is this for the CLLC in terms of what you're talking about? Because our PAC, a lot of things I could care less about, but I think a lot of people would, you know, give a lot or care a lot more about what you're.
Yeah, so our PAC is a completely separate thing. Also, our PAC is a PAC. We are not a PAC, technically speaking. The legality and the setup of the nonprofit is different for a PAC. And I don't want to go into all of that, but basically we're allowed to raise money for membership dues, and then we can contribute that money towards a lobbyist, and can use that lobbyist then to fight for our industry. So this is all about single family and small multifamily property owner rights in Colorado. It is the only voice at the state capitol now, really, that's specific to our industry. The only other voices really are that of large law firms like Cheddar Solzer, for example. They've been pretty involved. And then also organizations like the Apartment Association and the Colorado Association of Realtors. Now you may ask, well, why do we need this if we have the Apartment Association or we have CAR? So let me answer that for the Apartment Association. Sometimes what they are interested in and what they care about is not what we are interested in and what we care about. Sometimes we have opposing viewpoints on the way that these bills should be fought because it's really a different industry. With that being said, there are plenty of times that we can partner up with them. And for those of you who have been NARPA members for any length of time, you've heard from Nancy Burke. We've got a lot of value from that group and their willingness to sort of keep us in the loop. But they were doing that as a charity. And at the end of the day, our recommendations didn't have weight over the weight of their actual members. And since Nancy Burke left, we've had little to no conversation with their lobbyist. And other than the CLLC's lobbyist, who is now in conversation with their lobbyist, and we're kind of uniting to fight some of these efforts together. And then as it pertains to the question for CAR, you guys know the realtors have never really been all that involved with combating property management and landlord related bills. Most of what they do is private property owner rights and stuff that'll impact sales agents. There's been some exception in the last year because people like Andrea and other individuals who are extremely involved have been pushing it, but if it wasn't for that, we would have basically no voice through CAR. With that being said, we will continue to push that angle as well, and have as many voices up there as we can to fight the craziness that's coming. We've already seen conversation about the 30-day notice requirement being a permanent thing. So we went from a 3-day notice to a 10-day notice and could potentially go to a 30-day notice forever. That's scary. That's something that we're going to want to fight. We've already seen some conversation about a requirement that tenants have deposit insurance. And here's what's crazy. A company that I don't know if I want to name here is paying to get that is paying in many states to get that legislation pushed forward. So a company that provides deposit insurance is pushing legislators to create bills that require deposit insurance. It's some sneaky shit. So that one's already died, fortunately. But we're going to keep on fighting the fight here. But we're going to see you guys remember House Bill 1141 that we were freaking out about? Mm-hmm. Pertaining to late fee amounts and any other fees. Well, that one will probably be coming back. I don't know if it'll come back with the any other fees part of it, but certainly it'll be coming back with the late fee restrictions and how much we can charge in late fees and how long we have to wait to charge late fees. So there's a slew of bills coming, and really this is the only organization that's actively fighting that single family concern. So.
I had a question. I saw your post about the CLLC and the different levels of membership, but I didn't see really much as far as explanation of the difference in the levels. So really the only difference is from a recognition standpoint. It's kind of like if you're a member of PPAR, they're variable members of donors. Mhm.
And they kind of, I guess, give more recognition to those higher members.
Okay.
The only difference really besides that is that if you're a platinum member, you immediately get a spot on the advisory council table.
Okay.
You don't have to be recommended by a board member.
Got it. Okay.
And
Alex,
again,
what does a platinum cost?
It's
I'm sorry if you posted
$500 a month.
500 a month?
Yeah.
Alex, I had asked Rob for an email so that I can invite all of our owners to the group. And he said he was going to create one sometime this week.
Yes.
So that we can share that with all of our owners.
Yep. So the board, we meet once a week, at least for now. And tomorrow when we have our meeting, we're actually putting together a templated letter that we're going to send out to all of the NARPM members. I'll provide it on Cepm. You guys can just copy and paste it. It'll have if you want to join, and I hope you do, go to Colorado Landlord Legislative Coalition.org, and everything is set up on there to join up. And again, if you're not in a position to be a large sponsor, that's not a problem. We need lots of $60 a year people as well, and base members, not only for the money that goes towards paying our lobbyists, also when we want to say we represent X number of doors. We represent 4,000 doors in Colorado. So when you sign up, you're telling us how many doors you manage, so we can add that to our pool, and we can sort of present that.
Alex, would you recommend that we sign up as one company or multiple individual people underneath the one company, or does it matter?
I would probably recommend that you just do it as a company, because then frankly you'll get the recognition from the different tiers, instead of having a bunch of people at a basic level. But totally your call. With that being said, the only other thing I want to point out is that, as I indicated before, going into this legislative session, and there's going to be a special legislative session here probably within the next 30 days, even outside of the session starting next year, we will be on the defensive. That's unfortunate, but we will be on the defensive. I'm hoping that at some point we'll be in a position to say, hey, the habitability amendments really suck. Let's go try to fix a couple things to make them more balanced. Or the bed bug bill is horrible. Let's go make that more balanced. I think we can eventually do that. I'm optimistic that we can do that. But right now, all we care about really is defense. So.
Alex, question. How do you see that the lobbyist is going to be an advantage?
So, yeah, I'm glad you asked that. So the last time that I testified, and a bunch of you guys were there, but last time that I testified, Gonzalez Gutierrez, who is quite frankly one of our biggest challenges, she said, do you guys have a lobbyist? Because these people who are writing these bills, frankly, they don't want to talk to 2,000 people, right? They don't want to hear 2,000 different opinions. They want to have a united voice for the industry. So at this time, we don't really have a voice at that table. When they're drafting these bills and they go approach the different stakeholders, they're not approaching single family property managers. They're talking to the realtors, they're talking to the apartment people. Maybe they're talking to an attorney law firm who is paying to be at the table. But previously we just weren't a voice that was being heard because we were not considered a stakeholder. And frankly, they don't really take us as seriously unless we are. So that's the answer. And what's crazy is the second bill that I testified on, which was the applications bill, when I testified, they said, and this is Gonzalez Gutierrez, she said, I wish that we had talked to you guys sooner, which was like, oh God, like it just hit me because it was like, sometimes they do want to hear all sides. They do want to write a good bill. And if we don't have any voice, they don't even know what they don't know. And they don't even have the opportunity to amend it. Even if they say, hey, I'm going to do this bill no matter what you say, maybe it'll be a better bill if we're sitting at that table while they're in the drafting process. And having a lobbyist is the way to be at the table while they're doing that.
Thank you. That helped.
Any other questions? Okay, well, if you join up as a member, keep in mind that you will get a monthly, not only we have a high degree of accountability for the money that you're contributing, you're going to get a transparent copy of the budget. So you're going to see where all the money is going, but you're also going to get an update from our lobbyist on sort of what we're working on, what's going on. So you'll really be kind of in the inner circle as we're kind of combating these different things. But beyond that, I'll of course be posting stuff because that's how I do. I'll be posting on Cepm like crazy, I'm sure, and then the landlord forum that I run as well. So you'll at least hear about kind of some of those things as they're ongoing. And hopefully Pete's words today and feedback was helpful. I don't know about you guys, but at NARPM, I think maybe because they had some setup challenges and there was a bunch of like dinging noises during the meeting, it was kind of hard to pay attention to what was going on. Do you guys have any other remaining questions that you want to bring to the table about some of this upcoming craziness that you feel like you still don't have any clarity on?
I'm just shocked to learn that the source of income includes additional places beyond the government Section 8. That shocked the heck out of me.
Yeah, his words on that prompted me to want to go grab a highlighter and read through that bill again. Because I don't remember it, he knows better than I do, but I would encourage you to read the bill as well. And even like he said, you can speak to multiple attorneys and quite frankly, you're going to get different answers. I was talking with Daniel Muldoon last week about something and he was like, oh, my attorney told me this. I'm like, well, my attorney told me the exact opposite. So sometimes you have to get multiple opinions and then you weigh your options and make a business decision from there. So.
We had asked that question about unemployment quite a while ago with COVID and got that answer from Cheddar that unemployment would need to be considered a source of income since we were already in Denver. We wanted to know how would it be going forward in January for the rest of the state, but they had taken that position quite a while ago.
All righty, well, that's our agenda. Unless you guys have anything else, we're going to wrap this up. Are you guys all Zoom fatigued? I know I am. I'm so over Zoom.
I appreciate it today. Thank you.
It's the thing that makes me shower. I mean, I didn't put on any kind of nice clothes or anything, but I do shower. So
whenever there's a Zoom meeting is just when you shower.
This is good to know.
We can see you, not smell you.
Yeah, but it makes me feel better to not have, last week's mascara still on my face, just stuff.
I was just kidding.
All right. Well, I miss you guys. I'm grateful for all of you. I love our group. And I guess stay tuned. We'll keep on keeping you updated.
Thanks so much.
Alex.
Bye, everybody.
Thanks, Alexander.
Thanks, Alex.
Bye.
See you.